Hello, everyone, and welcome to Uncivil Law. For today's case, we're going to be covering a case that was requested by someone who is supporting the channel financially. Thank you for the contribution. If you'd like to support us, you can also hit the applaud button to contribute to us financially. It is always appreciated. And today's case we're going to be covering is the situation with the 3M ear hearing protection. 3M sold hearing protection for troops to use in the field. It provides some problems in terms of its effectiveness, and that is an issue. Now, this case has been settled. It was settled for roughly $10 million. And so 3M is paying out on this. So, and there's not, I read through the settlement, but the settlement itself didn't create any emissions. It just provided all the details of what cases are being resolved and whatever. And so there wasn't really anything for us to cover on the settlement. But what we can do is we can go back to the original complaint. So we're going to do that. We're going to go back to the original complaint and see what was being alleged, at least. And, on the basis that they settled, we can presume at least some of this was valid. So let's read what they originally complained about in this cause of action. This is an action by Qua Tam plaintiff realtor Moldix Merrick's in the name of the United States government to recover penalties and damages arising from false statements made by defendant 3M to the government regarding dangerously defective, dual-ended combat arm earplugs, which 3M sold to the U.S. military for more than a decade without its knowledge of the defect, without the government's knowledge. So the first thing we need to talk about is this term qua tam. So basically that term allows you to stand in the shoes of someone else. It allows you to take on the case as though you were someone else. Now, California has something very similar to this called the Private Attorney General's Act, which allows for this kind of thing in California law and is used fairly frequently. The United States government doesn't have many of these things, but there are a couple of them. And so basically, there are these bounty programs, for lack of a better description, because that's effectively what they are, right? So there are certain things that are violations against the United States as such. Now, the United States, of course, could bring its own complaint, right? The Attorney General could bring its own complaint, or someone else acting in an official capacity on behalf of the U.S. government could bring an official complaint, right? Because it's damages against the United States government. But both California in its state law and the United States, to a much more limited extent in federal law, has created a bounty program. Basically, long story short, is under certain circumstances, even though the damage is going to the United States, so the United States is the injured party, a private individual can bring suit and basically step into the shoes of the federal government. Now, the benefit for the private party is they get a cut of whatever ultimately arranges from this, right? So that makes it a bounty program, right? The United States government likes it because they're going to get the money for the damages that happen to them, right? The private individual likes it because they get money for the cut of the bounty program. So that's basically what's happened. So this private individual is bringing in action effectively in the name of the United States government. So they're stepping into the shoes of the U.S. government and saying, you harmed the United States government, and I'm going to bring an action as though I were the United States government, and I want money back. And if they win, then they get some money, and the government also gets money. So it's effectively a bounty program. So that's what's happening there. And so 3M sold these plugs for a long time. The U.S. military was buying them for a decade. So that's the allegation. Let's learn a little bit about this party that is pretending to be the U.S. government legally. Moldex is a family-owned business operating under the laws of California. It's a nice touch, with the principal place of business in California. It's in the business of designing, manufacturing, and selling worker safety products, including hearing protection and respirators. In 2011, Moldex introduced a nonlinear dual-mode plug called Battle Plugs. Good for them. Moldex Battle Plugs provided the first actual competition to the Combat Arms earplug in the market for nonlinear earplugs purchased by the military. So basically, this is a competitor to 3M. They produced a similar kind of earplug, at least in functionality. So it has two modes, just like the 3M plug. We're going to learn a little bit more about that. It's non-linear, meaning it doesn't have a linear response. It has some sort of non-linear response, right? So it acts differently at different things. So they came out with competition, and they're suing. This action arises under the False Claims Act, which allows, under certain circumstances, an individual to pretend that they're the U.S. government. So we have an individual pretending to be the U.S. government. Fine. So let's learn a little bit about these dual-ended combat arm earplugs from 3M. This is what they look like. They have a yellow side and a blackish, darkish side. So these are the plugs they look like. They have a kind of a standard three-flange design. I've seen many earplugs that have this kind of design. So, okay, fair enough. The 3M dual end earplugs were nonlinear or selective attenuation. They work differently at different kind of volumes, right? That's what that means. And they're designed to provide soldiers with a single set of earplugs that offer them two options for hearing attenuation depending on how the plugs are worn. So the two sides work differently. Okay. If worn in the closed or blocked position, which is the darker side in, the earplugs are supposed to sound like traditional earplugs. Okay. If worn in the open or unblocked position, the yellow end in, the earplugs are supposed to block or at least significantly reduce the loud impulse sounds of battle explosions while still allowing the wearer to hear quieter noise, such as commands by fellow soldiers and approaching enemy combatants. So, if you put in the black end, it's just an earplug. If you put in the yellow end, it's supposed to work in a way that, normal conversation can be heard, but loud impulsive noises like gunfire are blocked. Okay, fine. As known by 3M, also Arrow, at the time it won its bid and underlying indefinite quantity contracts that made the exclusive supplier of these attenuation earplugs between 2003 and 2012, these earplugs had a design defect that can cause them to loosen in the wearer's ear imperceptibly to the wearer, and even a trained audiologist visibly observing the wearer, thereby permitting damaging sounds to enter the ear by traveling around the earplug while the user or audiologist incorrectly believes the earplug is working. So they don't work. They can become unsealed and therefore allow the noise to bypass and therefore can cause hearing damage. Okay. Because the stem of the earplug is too short, it is difficult to insert the plug deeply into some wearer's ear canals and obtain a proper fit. Okay. So because it isn't long enough, it's hard enough to get it deep enough into the ear and therefore hard to get a good seal. Specifically, when the ear is inserted according to standard fitting instructions, the basal edge of the third flange of the non-inserted edge of the prone is prone to press against some wearer's ear canal and fold back to its original shape, thereby loosening the seal in the ear canal. Okay, so basically you push it far enough in, that third flange of the non-inserted edge is prone to press against the ear canal. So of the non-inserted end, right? Because we saw those three flange design, right? So let's go back to the picture so we can illustrate what we're talking about. It's a little bit hard to talk about in the abstract. All right. So what we have here is let's say we're going to put the black end in our ear, right? So we got the black end is coming in our ear, and all three of them are going against the grain, right? Because all three are going to be pushing against the flange in order to push them in the right direction, create the seal, right? But what we're concerned about is this really big flange, the fourth one, this yellow one, right? That's what we're concerned about. So if we push that far enough into our ear, then that cup, right, is going to hit against the ear canal, and it's going to fold up, right? Because this is supposed to be acting like a cap stop, right? But if we push it far enough into our ear, it catches the edge of that thing and pushes it up, and that allows air to come in a way that's not supposed to. So we can kind of see what they're talking about in terms of the design and potential flaw, right? Because as you're pushing this black end into your ear, all three of these are going against the grain, right? All three of them are being pushed the right way. But that fourth one is being pushed the wrong way. And so you push it far enough into your ear, then it no longer acts as a cup, it allows air to go by, and therefore it doesn't work as effectively. It makes sense. The defect has the same effect whether either end is inserted because the earplugs are symmetrical. Yes. So because it looks the same either way. So you would imagine it would have the same problem. In either scenario, the effect is the earplug may not maintain the tight seal in some ear canals, and dangerous silence can bypass the plug altogether, thereby posing serious risk. These dangerous design defects were known to Arrow in 2000 and later 3M when it completed the testing of the earplugs. So Arrow had the initial contract, 3M inherited the contract, and they were known to the companies, is the allegation. This is evidenced by the fact that when Arrow retested the closed end of the earplug starting in 2000, as detailed below, its personnel rolled back the non-yellow flange in order to mitigate the damage. So they could feel it being rolled back, and they actually had to physically push it, so they knew that this problem could occur, is basically the allegation. The technicians were aware of it because they'd have to manipulate to prevent it from happening, and they didn't tell anyone about it. That's the problem. Since 2003, 3M and Arrow have awarded multiple contracts in response to contract requests, issuing military bids to supply the nonlinear plugs. In each of these requests, 3M was required to certify its plugs complied with the salient characteristics required. Earplugs like 3M are sold with a listed noise reduction rating that's supposed to represent the amount of sound attenuation perceived by the test group when tested under certain conditions required by the methodology. The military can only purchase dual plugs if they meet the testing requirements. of the hearing program or equivalent standards that may be promulgated. Fine. So they have to have a certain noise reduction rating, and they can only buy them if they have a certain noise reduction rating. Makes sense. In or around 2000, personnel at Arrow commenced the testing on each end of the plug. Rather than outsourcing the testing to an independent lab, Arrow chose to conduct the testing at its own laboratory. So rather than sending externally for some certification, they did it themselves, which presumably would allow them to manipulate the test or ignore certain aspects of the test that might have been noted by a third party. So nothing necessarily inherently wrong by doing the testing yourself, but because you did that, you might have not taken note of certain things that other people might have taken note of. Okay. The Arrow personnel monitored the noise attenuation results of each subject as the test was being performed and could stop the test if they did not get the result they wanted, which would violate the protocol. Okay, so they are violating the testing protocol because they would stop the test if they didn't get the results they wanted, which is in violation of the protocol. There's a certain methodology you're supposed to use. They didn't use that methodology. They would stop the test, which you're not supposed to do. After 8 of 10 subjects had been tested on both the open and closed ends, Arrow personnel did not test the last 2 subjects with the closed blocked end of the hearing plug instead. At that point, the average results of the first 8 subjects suggested a noise reduction rating of 10.9, which was far below the 22 that would have been expected for the closed end of the plug. So that's a pretty big deal because if memory serves correctly, decibel ratings every 10 you go is a doubling effect. So the difference between 10 and 22 is double, which I suppose is somewhat implied by the numbers. But I believe that would have been true between 20 and 30, between 30 and 40, and so forth and so on. So basically, it was half of what it should have been. So, not so great. After prematurely testing the closed blocked end of the earplug, the personnel immediately investigated the cause of the block implied and unacceptably low and discovered that because the stem was so short, it was difficult to plug it into the canal announced in order to obtain a fit. So they figured out why it was causing a problem. Arrow personnel then determined in order for the test subject to obtain a proper fit, the flanges of the opposite side had to be folded back prior to being inserted into the subject ear. Okay, so there's a particular way you have to insert these things in order to work. Once they had identified the design defect, they decided to retest the closed blends using different fitting instructions. So for testing purposes, they provided different instructions on how to fit these. Okay, fine. As a result of this manipulated fitting procedure during the test, as 3M was aware, Arrow personnel achieved the 22 rating. So when they manipulated things properly, they got the rating they needed, following a different insertion instruction. 3M also knowingly used a deliberately reflawed test at the closed end of the plug for the military with the closed position. The standard instructions for proper use of the earplugs do not instruct the users to fold back the flanges before inserting. Instead, 3M improperly instructs simply to insert the plugs. So that's basically the point where, among other things, this is a point where this is going to break down completely, right? So, there are other problems here that we can all perceive, right? There are problems with the test. There are problems with retest, but the money problem, right, in the literal sense of the word, it's going to really be the big issue, right? As we try to spot what is the issue that most matters, right? As we try to spot what is the issue that most matters. The issue that most matters is we've figured out there was a design problem, right? If you insert them just normally, it can cause this particular problem. So we're going to retest them and give people explicit instructions on how to do this so it doesn't cause this problem. But when we actually sell these things, we're not going to tell them how to do that. We're not going to tell them. We're just going to tell them to just insert them normally. So even though we knew for a fact that if you just insert them normally, they sometimes don't work to the point where we retested them with specific instructions, we're not going to give the end user those specific instructions. To the end user, we're just going to say, just insert them like normal earplugs and they'll work fine. Even though we know for a fact, apparently, that they won't work fine. So that's the money problem. There are other problems here, right? There are problems not following protocols and all kinds of stuff. But the point where we're putting these in commerce and telling people, even though we know for a fact better, to do it one way when we know it sometimes doesn't work that way, that's definitely the biggest issue, at least as far as my issue spotting goes. In sum, as 3M Arrow was aware prior to selling the earplugs to the military, testing procedure and fitting instructions were unlawfully manipulated in order to obtain the noise reduction rating it wanted on both ends of the plug. And 3M Arrow had continued to use these inaccurate noise reduction ratings to market the plugs for 10 years without disclosing the defined defect in the plug. That is a no-no. You can't do that. 3M was further required to certify in response to each of the requests for contract that it provided accurate instructions. So it's required as part of the bidding process to say we're giving you accurate instructions on how to use this. As discussed above, 3M was aware at the time that the personnel folded back the flanges of yellow open plugs when it tested the open end and closed end and not similarly manipulated on the opening end. Despite knowing a flawed testing procedure, the instructions for use did not instruct and never instructed the wearer to fold back the flanges. Yeah, very good times. In 2006, the military entered into a contract with 3M, pursuant to which they would supply some stuff. According to the award notice for this contract, 3M guaranteed at least $9 million of sales in earplugs in 2006, which my understanding is that the settlement was for just shy of $10 million. I forget the exact number, 9.6, 9.8, but something like that. But they sold these things for 10 years. So effectively, they paid just a little bit more than 1 year of sales in damages for something that sold for 10 years. So a lot of people got hurt because, they're around really loud noises of gunfire and tanks firing and all kinds of crap. Their hearing is permanently affected. They're only having to pay $10 million worth of damages, and they got to profit off of it. So that makes me sad, but that's a thing that happened. Yeah. 3M's dual-ended combat earplugs were sold in the military in 2003 and continue to be sold indirectly and directly until 2015, so for 12 years. So we got a little bit more than 1 year of sales. So 3M walks away with effectively 11 years or 10.5 years or something worth of profits. So effectively, they walk away with 10.5 years worth of profits. The military members got their ears hurt, and, they're not actually going to get that much recovery. So that's a thing that happened. So that is the end of our current coverage of the case of the United States of America in the form of Moldex Metrics Incorporated versus 3M. In this case, we learned that Moldex, a competitor to 3M, sued 3M as though it were the United States government, which is allowed. And they sued 3M because they had caused damage to the United States government. What damage? By selling earplugs that didn't work to our troops who kind of, need them because they might be around loud noises, such as, tanks firing and guns firing and all kinds of crap. And the things didn't work because they caused a problem where they would ripple. And the company knew about it, but they didn't instruct anyone. And they sold them for 12 years and it caused harm to troops. So, shame to 3M. They've settled for roughly 1 year's worth of profits. And, the troops apparently are just SOL'd. They should have known better or something. I don't know. It's a story that's distressing. If it were up to me, 3M would have to pay a lot more in damages because it caused a lot more of harm. And they're selling things to our troops who actually need them. And, they're not being very good Americans. I'm not feeling a lot of USA patriotism from the 3M company right now. And that's the end of our coverage in this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.